Hello and welcome to Timmy Mac Law with me, Mr. McClellan. For this video we are going to focus on the Occupiers Liability Act 1957. Not to be confused, of course, with the Occupiers Liability Act 1984, because the Occupiers Liability Act 1957 does deal with lawful visitors and the duty that an occupier has to owe to lawful visitors to ensure their safety. So just be clear on that, 57, not 84. That is for trespassers, 57, lawful visitors. So it does include an occupier's duty towards adults, children or workmen. And you'll see from the structure of the content here that I've very much distributed the different sections covering adults, children and workmen. So that to look forward to. It also includes a statute damage insofar as personal injury and damage to property, or indeed both, of course, at the same time. Now, the first key question that you must always ask yourself regarding occupiers' liability, whether in the context of 1957 statute or the 1984 statute, is who is the occupier of a premises? Now, in order to work out that foundation question, you've got to know who has a sufficient degree of control. Learn that quotation. Does the occupier have a sufficient degree of control of the premises? And if the answer is yes, then they are the occupier under the terms of the Occupiers Liability Act 1957. If the answer to that is no, well actually they are not the occupier, so the claim should not be made against that person. And if it is, then the claim will fail. So in essence, who is in control? That's the key question. But do learn who has a sufficient degree of control. And your go-to case for this is Wheat versus Lacan, but do be aware that there can be more than one person in control of a premises, so more than one occupier, and also no one at all. And if no one is found to be the occupier, then you should not pursue the claim, or indeed if you do, the claim will fail. Go-to case, Wheat versus Lacan. Think who is the occupier of a premises and instinctively attach to that Wheat versus Lacan. Now, as ever, when we go through these cases, I'm very much going to give you the crux of the case rather than the detail. There are quite a lot of them, and in an effort to get through this, we're going to have to do it quite quickly. So I'm going to try and hit the nub of the issue, oversimplifying it really, if truth be told. But in this particular case, Wheat versus Lacan, the claimants were staying at a public house, and the claimant did actually suffer an injury from falling down the stairs because of a handrail which wasn't long enough and because a light bulb had not been replaced. And in essence, it was about who they should make the claim against. Who was the occupier of the public house? Was it the managers of the public house, a Mr. and Mrs. Richardson, or was it the brewery who acted as the landlord of the property? And as it turned out, it was ruled that both of them were the occupiers, so the claim could be made against one or the other, which just highlights that there can be more than one occupier of a premises. In this particular case, Harris versus Birkenhead, you had a 4-year-old child who wandered into a derelict house, which the council had issued a compulsory purchase order on. So effectively, they were the ones who had sufficient control of this property, even though they had never stayed in it, or indeed a member of the council had never used it as their dwelling. But because they had issued that compulsory purchase order, they did have a sufficient degree of control over that premises, and the claim succeeded against them. And in this case, Bailey versus Armes, it was where a child wandered onto a flat roof above a supermarket, having left the window of a flat. And in that case, the supermarket or the flat owners, neither of them were found to be the occupiers. Neither of them, it was found, were having a sufficient degree of control over the flat roof. So the claim against the defendant failed in that case. Once you've worked out that particular conundrum, who is the occupier of a premises, you go on to your next key question. And again, this key question should be answered effectively no matter the situation you get regarding occupiers' liability, whether it's to do with the 1984 statute or the 1957 statute. So these are very much constants of your determination of occupiers' liability. And the question is, what is a premises? Well, the nub of this is there is no statutory definition in law of what a premises is. But in essence, it can be a movable or fixed structure. So most commonly, it's going to be a building, whether that's a home or an office or a factory, some sort of manufacturing type location, but it also could be land as well, and a vehicle, hence it can be a movable structure such as a caravan, for example. So just be aware of that, and normally it's really clear, particularly in scenarios that it is a premises. But even if it is clear, you must address that question. It can be considered to be a premises because it's either a fixed or movable structure, despite there being no statutory definition as to what a premises is. And then we get our three different types of people, which we're going to address here. So we've got our adults, we've got our children, and we've got our workmen. Now, for each of these type of people, you would be well advised to actually focus on, are they an invitee? Do they have contractual permission to be on the premises? Do they have a statutory right of entry, or are they a licensee? So even though I've put that here with the adult section, you can address that for children and workmen as well. So identify not only the obvious type of person that they are, adult, child, workman, but also the type of visitor that they are. Invitee, contractual permission, statutory right of entry, or a licensee. Invitee, really easy, you've invited that person onto your premises, just like saying to a friend, come on over for a cup of tea. Contractual permission, well, this really applies to those people who've entered into a contract to be on the premises. And the most likely way in which you are to do that is if you hand over payment to be on the premises. So cinema goers, going to the theatre, guests at a hotel, all have a contractual right of entry and permission to be on a premises. Statutory right of entry really applies to police officers who've been issued a warrant, or I suppose less obviously electricity or gas, water, meter readers who may want to come onto your property. I know we have smart meters nowadays, but still I think it's fairly common that you will want to get in meter readers to come into your property so they can take the correct readings of your gas, electricity and water. And if you refuse those people too many times, they can get a statutory right of entry to get an accurate reading of those particular meter readings. So you can complain all you like as to a police officer coming onto your premises when you don't want them to, or meter readers, but if they've got that statutory right of entry, then they're allowed onto the property, irrespective of what the occupier says in terms of their complaint. And then we have a licensee, and these are for people who have implied or expressed permission to be on the land. And these are pretty common. So implied permission really applies to those people who are delivery men, for example, the postman who walks through your garden gate and rings your doorbell. So by having a garden gate and a garden path and indeed a front door, you're basically giving implied permission for certain types of people to come onto your premises. And we normally take these people for granted in terms of whether they have a right to come onto the premises, but equally you can refuse their implied permission. You can revoke it, but you must clearly inform that person whether it is verbally or in writing, and then they must leave your premises in a reasonable amount of time. But they're normally the people who have an implied license to be on the premises. Also, we've got those people who have been given an express license to be on the premises. So they've got written permission from yourself, even verbal permission, but it can always be useful to get a witness with that verbal permission and to enshrine that permission in writing. But it's really clear, that's what express permission means. Now, rather interestingly, implied permission, so permission is really sort of hinted at, there's an inference of permission, then that can apply to repeated trespassers. Now, normally you instinctively think trespassers, that's the 1984 statute. However, where you have a repeated trespasser and a defendant, an occupier, knows that trespassers are coming onto the land and they are repeated trespassers, they know there is a foreseeable risk of danger to them, and yet they take no action to guard the safety of those trespassers, then they can have implied permission, they can gain effectively implied permission to be on the land. So just remember that an implied license can be given to repeated trespassers. It is a quirk that you will often find in occupiers liability scenarios. So just be really mindful of it. And the case Lowry versus Walker beautifully highlights the significance of a repeated trespasser, because in this case the defendant owned a field and also a horse which they knew to be dangerous, and the claimant was a repeated trespasser, but they'd never been warned against their trespassing. Their trespassing had never been guarded against, so because of that inaction by the defendant, when their horse injured the claimant, the defendant was liable for that particular claim. So really useful to remember that, and there are certainly a few marks in remembering that. It does often appear in your occupiers liability scenarios. The nub of what an occupier must do to all visitors, but in this case to adults, they must ensure that visitors are reasonably safe. And by that, and this is worth remembering, not only that short phrase that an occupier must ensure that visitors are reasonably safe, but they must take reasonable care in the circumstances that visitors on their premises are reasonably safe. So reasonable care in the circumstances to ensure that visitors are reasonably safe. They don't have to be completely safe, and nor does an occupier have to guard against obvious dangers. Otherwise, quite frankly, you could well be opening the litigation floodgates there, whereby courts are stuffed, ran full of claims arising from obvious dangers, which essentially a visitor should be wary of themselves. So, nice case to remember here, Laverton versus Kia Pasha Takeaway, and we've all been there, guys, after a boozy night out, which the claimant, by all accounts, had, and they wandered into a takeaway. Probably something like a kebab, but nevertheless, it was a rainy night, and the claimant, wearing her high heels, I presume it was a girl, a female claimant, and then she slipped and injured on the wet floor. And no doubt the floor was getting wet by customers coming into the takeaway and, of course, making the floor wet with rainwater. Well, the question is here, had the occupier ensured that the premises was reasonably safe? Had they taken reasonable care in the circumstances to ensure the reasonable safety of their customers? And it was ruled that they had mopped the floor 6 or 7 times that particular evening. It was an inevitability that rainwater would come into the shop. They had to do business. They had done all that they could to ensure that the visitor was reasonably safe. And of course, it was considered to be a rather obvious danger. You would know it was raining outside and probably realise that the floor was wet too, with all the customers in there. So the claimant failed in that particular action. In terms of obvious dangers, you've got Braille versus Rochester Cathedral, and here you've got the claimant who has injured themselves on a piece of concrete that was apparently protruding, sticking out from a damaged bollard. And it all centred on, had Rochester Cathedral done all that they could, reasonable care in the circumstances to ensure a visitor was reasonably safe, and it was ruled on appeal that they had. And in this case really highlights the wariness of courts not to open the litigation floodgates. We are perfectly aware as pedestrians that sometimes the paving isn't necessarily 100% perfect, and nor could it ever be wherever we decide to walk in those pedestrianised areas. And it was ruled that Rochester Cathedral had done all that they could. They'd taken reasonable steps, but they can't make their property completely safe, only reasonably safe in the circumstances. Now, the next line, absolutely crucial, worth getting your phrasing, bob on with this. It is the state of the premises that must pose a real source of danger. Not any activity on the premises as such, but the state of the premises. So rather than just talking about the premises causing a danger, it's got to be the state of the premises causing a danger. Rather than talking about an activity that was inherently dangerous on the premises, it's got to be the state of the premises which poses a real source of danger. So get that instilled into your memory so it is instinctive for you. So there you have it, occupiers liability to adults. Much of that does apply to the specifics of dealing with children as well. But to actually get to the specifics of children, well, there are some hints and tips that you can grab here, essentially working on your common sense. This is not rocket science stuff, common sense questions that you just need to bring to the fore. So with respect to children, children must be reasonably safe for a child of that age. So you've got to work out really, within reason of course, that young children, small children, let's say under the age of 5, they do require an awful lot of care. So therefore the standard of care that you've got to show to child visitors when they're particularly young, it's a high standard of care. Normally, as a nice kind of foundation to rest upon, there is a higher duty of care for all children, but particularly for younger tots, as it were. The older a child gets, you can lower the standard of care within reason. This is all about interpretation and judgment, of course, but do be aware of that guidance. So the property, the premises has to be reasonably safe for a child of that age. Use your judgment regarding that. And whenever you get an age mentioned in the scenario, which is really often, they've done that for a reason. So pick up upon that. It will affect the standard of care. Go-to case here, Glasgow Corporation versus Taylor. So here you had the claimant going to the Botanical Gardens of Glasgow. Sounds absolutely lovely. Rather tragic circumstances though, insofar as the child actually ate a poisonous berry and died. Now, the crux of this case was, had the Botanical Gardens of Glasgow ensured that the child was going to be reasonably safe on their premises? Now, the berry would represent an allurement for a child, and a foreseeable allurement which could cause a foreseeable risk to the child. So they just really have guarded against that, either put some netting around the plant perhaps, or just remove the plant entirely, because it was perfectly foreseeable that a small child would see that berry as an allurement. So therefore the claim succeeded against Glasgow Botanical Gardens, and I think understandably so, given the small age of that child. Adult supervision must be expected, so adults cannot negate their responsibility to their children. And the obvious question is, when a child gets some sort of injury on a premises, what were the parents doing, or indeed the guardians of that child doing at the time? They cannot absolve themselves from responsibility. So here we've got Phipps versus Rochester Corporation, and he had a 5 and 7-year-old with no parental or adult supervision to speak of, falling into a trench, getting injured, no liability on the part of Rochester Corporation. In essence, what were the parents doing? They had responsibility for those children in terms of supervision, and it just wasn't there. So the claim against Rochester Corporation failed. Allurements to be guarded against, we've already mentioned that with respect to the berry in Glasgow Corporation versus Taylor. Rather interesting case in Jolly versus Sutton Borough Council. Now, in this case, you had a derelict boat that the council had issued a compulsory purchase or order over. So effectively it belonged to the council, and they did state that they were going to remove it, but they didn't remove it. It was just left sitting for people, passers-by, to actually look at the boat, touch the boat, and do really what they wanted to with the boat. And two rather inventive and I have to say quite mature 14-year-olds decided to actually repair the boat. Now that could be quite unexpected for 14-year-olds. Hate to be cynical, but perhaps you would expect 14-year-olds to be more likely to further damage the boat. But that wasn't the case with these two 14-year-olds. They decided to repair it. Now, unfortunately, tragic consequences for one of the 14-year-old boys. They used a jack to lift up the boat in order to make repairs, but the jack went through some of the rotten wood on the boat, and it caused the claimant to become paralysed. So tragic consequences for the claimant. Now, key question regarding this was it a foreseeable source of danger? Did it pose a real source of danger to any visitor on the premises? And much argument regarding this, because would you expect 14-year-old boys, over a period of weeks, it has to be said, to do up the boat? And no, you wouldn't. And that was essentially the outcome of the first trial. But on appeal, and this case went all the way to the House of Lords, it was found that it was foreseeable that the boys would meddle with the boat, not necessarily repair it or indeed damage it as you would expect perhaps 14-year-old boys to do, but would they meddle with it, toy with it, tamper with it in some way? And that was foreseeable. So it did represent an allurement, and that had to be guarded against, and Sutton Borough Council had failed in their duty to do that. So all that taken together, that's occupiers liability and the sorts of things that you've got to look out for with respect to children. And then finally, in terms of our type of visitor, we have got workmen. And this is a really common occurrence, as it is for children as well, but also workmen too. And with it, because it appears in scenarios a lot, workmen should guard against risks ordinarily incident to their calling. Get that quotation remembered. It will stand you in good stead, because there's a high likelihood that if it's not children coming onto a premises, it will be a workman. It's actually probably relatively rare that you'll get a straightforward, as it were, adult coming onto a premises. The examiner will make it a little bit tougher for you and apply a child as a visitor or a workman. So you're going to have to think a little bit harder with respect to the type of visitor that a child and a workman is. So workmen should guard against risks ordinarily incident to their calling. The essence of that is that a workman should be careful with respect to any risks which they ordinarily come across in their job. So, as an example, an electrician should guard against risks inherent in dealing with electricity. A plumber should guard against risks inherent in dealing with water. A roofer should guard against any risks in terms of getting on top of a roof and working at height. So, ordinary incident to their calling, it's up to the workman to guard against that. It's not necessarily the responsibility of the occupier. That is the reason, after all, as to why they've instructed the electrician, the plumber, the roofer to do the job that they are qualified and trained and experienced to do. So, remember that quotation. Ordinarily incident to their calling, that is the responsibility of their workman. Nice case to remember for this, Rolls versus Nathan. And here you had two chimney sweeps who were repeatedly warned that there was carbon monoxide poisoning in the particular flumes that they were looking to clean, and they should wait till the carbon monoxide, which is poisonous, it can kill you, had dispensed. And they didn't wait. They wanted to get on with the job. They ignored official advice, as it were, and then unfortunately they were both found dead. There was no liability on the part of the defendant because they had ignored advice. They had not guarded against any risks, ordinary incident to their calling. Carbon monoxide is a risk that chimney sweeps will recognise and should recognise. Essentially, the claimants didn't listen to any warnings or advice here. Salmon versus Seafarer Restaurants is an interesting case. So, in this particular case, the defendant negligently left a chip fryer on. And remember, the word negligently, you've not met the standards of the reasonable man. You've done something that you really shouldn't do, or you haven't done something that you really should do. And if you own a chip shop or a fish and chip restaurant, as it were, then you've got to double check, treble check that you turned all your fryers off. And essentially, one of the fryers was left on, the chip fryer went up in flames, and the fire service was called to deal with that emergency. Now, one of the firemen, in attempting to deal with that emergency, suffered from an explosive blast which caused injury. And they made a claim against Seafarer Restaurants. And the defendant tried to argue that essentially an explosion was ordinarily incident to the calling of a fireman. And I suppose in some respects it is. Firemen will have to face explosions. They may be rare, but they are associated with fires, of course. However, the outcome of the case essentially held that firemen, even though they have to deal with exceptional risks and emergency situations, they have as much right as an ordinary person in ordinary circumstances to make a claim which will be successful if all the other criteria is satisfied. So the firemen had guarded against all risks ordinarily to their calling. You can't really guard against an explosion in the context of trying to put out a fire. Essentially, you've got to do your best to get on with the job, I'd have thought, to put the fire out, and therefore the claim on behalf of the fireman, the claimant, did succeed. So we shouldn't have unfair expectations against emergency workers, firemen in this context, so long as they've guarded against risks ordinarily incident to their calling, they've done everything that they can. If they face an exceptional risk that they can do little about, they should be able to make a successful claim. Reasonable care must be taken in engaging and checking the work of a workman. So in terms of engaging a workman, you just need to make sure that they are qualified. You've got to make sure that they are experienced. They come with some recommendation. And in doing that, you've carried out your due diligence in engaging that workman. And therefore, if you do that effectively, you are not going to face liability. And in this particular case, Bottomley versus Todmorden Cricket Club, there was a pyrotechnic, a firework display, from which somebody got injured. And liability was found to be on Todmorden Cricket Club because they hadn't done their due diligence in checking the qualification of the people who ran this pyrotechnic display. So you've got to check that the person you are engaging as a workman qualified, experienced, and comes with recommendation as well. Now, in terms of checking the work, the complexity of the work has to be a factor here. There is a reason why you engage workmen, because perhaps you cannot do the work yourself, perhaps you don't understand the nature of the work, it's far too complicated for you. Now, where you do understand the nature of the work, and you can check it effectively because it's relatively simplistic, you could face liability because you would be considered to be negligent. You may not have done the job or repair yourself, that's the job of the workman, but you could check it yourself so long as it takes, well, some common sense steps to do that. However, if the work is too complex, it's unlikely you're going to face liability. That's why you got the workman in the first place. If you do think it looks a bit dodgy, then you probably need to get a second opinion. So, in this particular case, Woodward versus Mayor of Hastings, and then we've got Hazeldine versus Dorr. So in Woodward versus Mayor of Hastings, you had a cleaner in a school who swept the snow off a church step, and it led to ice being revealed, but she failed to actually grit the ice to make it safe, and a child fell on the ice suffering from an injury. That was the claimant. Now, there was some wrangling about whether the cleaner should take responsibility as the workman or whether it should be the school itself, and indeed one of the school governors, I assume, was the Mayor of Hastings, and it was ruled that indeed the school faced liability. They could have checked the work of the cleaner, and she was an agent of the school, okay? So it wasn't a case of trying to put all the blame on the cleaner. Yes, she probably would have done a better job, or should have done a better job by de-icing the step, gritting it, but the school could have checked that the work had been done effectively, and they had failed to do that. Because it's a simple job, and checking it would have been simple as well. Where the work was a little bit more complex, you can see in the case of Hazeldine versus Dorr, and in that case you had a landlord that engaged a lift engineer once a month to maintain and repair a lift, and the engineer failed to repack the lift effectively. Not entirely sure what that means, but in essence they hadn't done a sufficient maintenance or repair job on the lift, and a claimant was injured because of that. And the landlord, it was found, had taken reasonable steps in the circumstances to ensure that their property was reasonably safe. There's that line again, but they couldn't really check the quality of the work of an engineer. I don't know about you, but I know very little about engineering, and I know even less about the engineering with respect to lifts. Complex work. The landlord had done all that he could in having this routine of getting a lift checked. It was up really essentially to the engineer to do their job effectively, and the landlord couldn't check the quality of that given its complexity, and therefore the landlord avoided liability. And then finally we come to warning notices, which effectively act as a defence to occupiers' liability. So in terms of a warning notice, which can allow a defendant to avoid liability because they have warned a visitor of a real source of danger, the warning notice must be oral, so verbal, or written, it must be understandable, and it must be visible. Now normally this sort of stuff is obvious, but any kind of indication, particularly a warning sign, it has to be understandable. That's why warning signs are quite blunt and simplistic in terms of their language, and it has to be visible. It cannot be teeny tiny, make it big so people can see it. Providing you've got that, then a warning notice is only required if you expect visitors on your premises. If you don't expect any visitors on your premises, you've never had them before, you've never recognised them there before, then you don't need a warning notice. And you don't need a warning notice either to guard against obvious dangers. That should be up to the visitor to show their own common sense. We've got 4 cases here which highlight the importance of a warning notice and whether they are necessary or not. So the first case is Tomlinson versus Congleton, Buret Council, not too far away from me, Congleton, and there is a country park called Brereton Heath. Now, in Brereton Heath Country Park, there was an old sand quarry and it had been filled with water. And many people like to go for a swim in this water, despite the warning sign that said you should not do that. And the claimant did go for a swim. They suffered injuries as a result of swimming in the old sand quarry and brought a claim against Congleton Borough Council. But even though Congleton Borough Council had to face the argument that the warning sign represented an allurement for a young man, that was one of the arguments raised in court. What are the council to do? Warning signs as an allurement? Really? Otherwise, anything in theory could be an allurement, particularly for a young man. But there we have it. That particular argument was discounted, and essentially this posed an obvious source of danger. And the warning notices put up by councils up and down the country are regularly ignored. And what else was Congleton Borough Council to do? Rope off the sand quarry so no one could enjoy it in terms of the visual appearance of it, fence it off. Well, that seems like an unsavoury precedent to set. Essentially, visitors in that circumstance have to use their own judgment. They are acting out of their own free will, and therefore the Borough Council, Congleton Borough Council, avoided liability. Donahue versus Folkestone Properties. So, Folkestone, down in Kent by the sea, and you have the claimant on Boxing Day, in the middle of winter, deciding to go for a swim at midnight. There was no warning notice near the particular harbour where this swimmer decided to take a dip, and indeed it was ruled that no warning notice was required, even though swimmers did go in the sea in the summer, and it was necessary to guard against those visitors and the risk associated with swimming in the summer. And indeed, Folkestone Properties did engage security guards to ensure that visitors were not engaging in any risky activity, or indeed the state of the premises represented a risk. That was in the summer though, but in the winter, would you really expect anyone to go into the sea in the winter? It would be freezing. Surely it is becoming of the visitor to use their own common sense, and that's the way it was ruled. The claim failed. They had done all that they reasonably could in the circumstances, reasonable care in the circumstances. Kia versus Coventry Healthcare Trust, small child playing on a fire escape. There was nothing inherently dangerous regarding the state of the premises, nothing inherently dangerous regarding the fire escape. What was dangerous was the child's activity on the fire escape, and that was up essentially to the child and indeed their parents to take responsibility for. So state of the premises, no real source of danger regarding that. It was more about the activity, so therefore the claim failed. No liability on behalf of Coventry Healthcare Trust. And then the final case, Ratcliffe versus Mcconnell. You had a group of students who decided to go swimming in a swimming pool. Funnily enough, it was fenced off, it was guarded and locked, and yet they managed to get in and take a dip, and unfortunately one of the students suffered paraplegia from diving into the shallow end of the swimming pool, despite the warning signs that were clearly there. It wasn't a regular occurrence for the defendant to have swimmers essentially trespassing in the property, and again the warning sign was sufficient to avoid liability, and again with the argument that really the own free will of the claimant really created the injury. It was the activity which was dangerous, not so much the state of the premises. It represented an obvious danger. Quick points to remember as well, in addition to all of this, do note exclusions of liability can also act as a defence, but it's unlikely that you're going to need to reference this in a tort-based scenario because that's more relevant to contract law. Exclusions of liability are statements such as the occupier would accept no responsibility for death or personal injury to any visitor on this premises. However, that exclusion notice will not work where the occupier has been negligent, so it isn't a get out of jail free card, essentially by putting up one of those exclusion notices, and the exclusion notice must in itself be fair, but that is more relevant to contract law and unfair contract terms, so it's unlikely that you will have to state this in any answer that you give an occupier's liability, but just for your own wider knowledge, as it were. And do remember the importance of recognising contributing negligence and the full defence of volenti non-fit injuria consent, because when it comes to occupier's liability, visitors will be using their own voluntary behaviour, their own free will, and that brings into conversation contributing negligence. Have they contributed to their own negligence, and therefore liability on the defendant could be reduced because essentially the claimant has to accept some responsibility, or indeed they've willingly accepted the risk. So whenever you talk about occupier's liability, it's likely that these two defences are never going to be too far away. Quite long-winded stuff. Hopefully that was useful for you. Thank you very much.